When a person, or to give them their proper title, a settlor, creates a trust, there are certain formalities that they have to go through. If you're answering this topic in a problem or an essay question, then the key case that you'll want to start with is the judgment of Lord Justice Turner in Milroy and Lord from 1862. In this case, he outlined two key principles that have to be abided by. Firstly, there has to be a valid declaration of trust, and secondly, the property has to pass in terms of its legal title to the trustee. In this lecture, we're going to explore those principles in more detail and also look at some of the exceptions as well. Right, let's get started. So let's start with some of the more general principles before moving into specific examples. And we can start off by saying that the settlor has to actually have a proprietary right in the property that they are establishing a trust over. In other words, I wouldn't be able to create a trust over my neighbour's television because I don't own it. This principle comes from Justice Windeyer in Norman and Federal Commissioner of Taxation, which is an Australian case from 1963. Perhaps more specific to this principle is that I would not also be able to create a trust over property I will get in the future. So I can't create a trust over my paycheck for next month, and this comes from Revoke's settlement trust in 1939. There are possible exceptions in cases of estoppel, but generally this is a pretty sound principle. In a similar fashion, once a trust has actually been created, it cannot be undone by a settlor, and this principle comes from Paul and Paul in 1882. The power to revoke a trust can technically be included in the trust instrument, but this is very unlikely as it has significant tax implications for it. While a settlor cannot undo a trust, beneficiaries can both enforce and revoke a trust, and we saw this in the case of Saunders and Vautier from 1841. So let's move over to some specific examples, and we'll start with trusts over personal property because this is probably the easiest. So, to put it simply, there's no formalities required. So let's go back to my example, and this time I'm going to create a trust over my own television. Well, I can do that any way I want to, and there's no formalities that I need to jump through. This is from McFadden and Jenkins in 1842, so quite an old principle. It means that trusts can be declared orally, as was the case in Paul and Constance, and it can also possibly be inferred by the courts, as in Re Cayford, which is a case we've looked at previously. One slight formality that may occur is that in the cases of shares, these actually have to be registered in the trustee's name, but generally for personal property, there's no formalities required. A bit of a different case for land though. Normally a trust over land is created by a deed, although it could technically be anything in writing, and something that is signed by the settlor, and these requirements are set out in section 53(1)b of the Law of Property Act 1925. All of the terms of the contract and the trust have to be contained in one document as per section 2 of the Law of Property Miscellaneous Provisions Act 1989, and once that trust is set up, it's governed by Tellata, or to give it its full name, the Trusts of Land and Appointment of Trustees Act 1996. Our final specific example comes when we're creating a will. This is governed by the Wills Act 1837, and per section 9, it has to be in writing, signed by the testator, i.e. the person creating the will, and also signed or attested to by 2 or more witnesses. So some general exceptions that can come up are that resulting, implied and constructive trusts, i.e. things that are not express trusts, do not necessarily require formalities, and this is stated in section 53(2) of the Law of Property Act 1925. To put it very simply, the reason for this is that we don't want people to benefit from their fraud or things like that on the basis of the way they've acted, and to benefit from the lack of formalities in such a trust situation. Moving on from this, we can see that cases of fraud or unconscionability in general can also mean that the courts do not require the usual formalities, and in this regard Rochefoucauld and Bousted from 1897 is a particularly instructive case, and we can see how the courts can operate in an equitable manner when it comes to looking at the formalities and the possible exceptions. So in an ideal world, that will be how express trusts are created. But as we all know, real life is never that neat. And so in a future lecture, we're going to be looking at some of the more grey areas where the courts have had to step in and deal with trust situations. Well, I hope you enjoyed this lecture. If you did, make sure to leave it a like. Also subscribe for more videos in the future. And if you have any questions, then leave those in the comments below and I'll make sure to get back to you. Thanks very much for watching. Bye!